I want this to be fairly informal. I have some things that I want to share, but then I also want to have time to open up for questions. And I am joined by Stephen Eck. Stephen is the General Counsel and actually the Plan Giving Vice President at Oklahoma Christian. And so Stephen is a great, great expert in this area. As Bill mentioned, I am a lawyer. My wife is a lawyer as well. We married, and a month later we began law school together out at Pepperdine. You want to have a good study group when you go to law school, and I had a very good study group. It was my wife, Darla. She would read the case law prior to me looking at it, and I would read what she highlighted and underlined, and it worked out really, really well. So find a good study group. Let's talk stewardship in general just for a second. I want to ask you a question. When you think about the concept of stewardship, are there stories in the Bible or characters in the Bible that come to mind for you?
The widow who gave her 2 coins in Luke.
Okay, great. Great example. You remember rich people were putting money in. The widow put all that she had, and Jesus talked about that her gift was so very special. Great, Richard. Great example. Other examples of stewardship.
Parable of the
talents. Okay. You have some that really treat what the master had given them very, very well, and then you have the bad servant who buried his, didn't do anything with it. That's a great example also.
prodigal son.
Okay. Wow. Great example of squandering everything. You want it before you're entitled to it, and you're willing to sacrifice a family member for it, and then you take it and it just disappears because you don't treat it well. Great, great example. Okay. Jesus as an example of a great steward. Very good. What about, can you think of any examples in the Bible where somebody had property and they decided to do something with it? Okay, 2 great examples, kind of polar opposites. You have Barnabas, the encourager. He sells what he has and he gives it all. And then you have Ananias and Sapphira, who also had property. They were property owners. And they sold it and gave a portion of it. Doesn't appear that it was really wrong to only give a portion of it, because they were giving that to a good cause. But the way they went about doing that, and the way that they held the truth to themselves on what really was happening. Any other examples that come to mind? These are all very, very good examples of stewardship. Oh, yeah, okay. Man, the rich young ruler, he had it all, and he was keeping all the commands. But there was one thing that Jesus asked of him, and he would not do it at that moment. I'm a positive thinker, and I'm hopeful that later the rich young ruler made a change. And he actually did realize that Jesus was much greater than all of the riches that he had. Ken?
Naboth, he wanted to keep his property and be a steward of it. And Ahab and Elijah said, no, we're taking that. But Naboth was trying to be a good steward and be responsible with his inheritance he received.
By the way, Kent Hartman, Bible faculty member at Oklahoma Christian, teaches a class on Christian finances that the students love. And he also told me as this class began that he was sitting closest to the door so he could get out whenever he wanted to. So he's being a good steward of his time as well, I suppose. Yeah, Stephen?
Thinking about David, when he purchased the threshing floor of Araunah after the angel of the Lord had slayed 30,000 people, and he told Araunah wanted to give it to him. He said, I will not sacrifice to the Lord something that costs me nothing.
Ah, wow, very good. David, I will not sacrifice to the Lord something that cost me nothing. Yeah, that's a great example.
It was Solomon who had all the wealth and then denied God in the end anyway.
Solomon, good example of the direction not to go. He began certainly correctly, and asked God for the right thing. And God blessed him in a lot of ways, but that didn't end well. I want to share one example of stewardship that maybe you've not really thought of as a story of or an example of stewardship in the Bible. I am thinking of a character who had very important God-given assets. This character also had around her some very good advisors. And the third thing about this particular character is she listened to the advice of those advisors, and I think she stewarded her God-given assets because of that. I just heard it whispered. Esther. Now think about Esther. Did she have property or wealth? We're not aware of that. What we do know she had great beauty. That's one asset given to her by God. We also know that for some reason her parents were gone. They had passed away, and she was being raised by her uncle Mordecai. She got very good advice from Mordecai. You remember the story. Vashti, the queen, wouldn't come out. The King Xerxes, decides to put her away. His advisors go on a nationwide American Idol type hunt to find the perfect wife for the king. Well, Mordecai encourages Esther to be open to that. And I don't know if you remember, when Esther became a part of that, let's say, competition, she actually listened to another advisor. There was a eunuch that was in charge of some of those young maidens, and he would make suggestions, and she would listen to those suggestions. She got very good advice from him as well during that process. So Esther had this asset given to her by God, her beauty. She had at least two very good advisors around her. And the third thing is she listened to their advice. And consequently, she took assets given to her by God and parlayed them into doing something very, very significant for God's people. I think Esther is a great example, one that I don't think of very often as an example of stewardship. Now, what I want to do this morning for a few minutes is talk about a particular area of stewardship. And that area of stewardship really deals with the scheme that we are a part of in terms of the estate planning realm. There are state and federal laws that impact estate planning, and this is one of various kinds of stewardship opportunities that we have. So there are two premises I want to share with you initially. I believe that God desires that we be good stewards of what He has given us. And I will tell you, sometimes I forget that the good things that I have are gifts from God. Sometimes I think, you know what? I've got this car that I really like because I'm a really good guy. And I earned it. And I deserve it. Well, you know what? Everything that I have is a gift from God. And what I have, I'm really just in charge of for a pretty brief period of time. And I believe that God really desires that we be good stewards of what He has given us. It's not a mistake when Jesus said it's harder for rich people, it's harder for rich men to get into the kingdom of God because of their riches. And I tend not to think about that. The second premise is, I think to be good stewards, we really need to be informed, and we need to understand the law, and we need to understand options in this particular realm in estate planning. So that's what we're going to talk about for a few minutes, and then we'll open up for questions. So here are some common misconceptions and issues regarding estate planning. I don't need an estate plan because I don't have anything. Lots of folks say, you know what, this is not important to me because I don't have anything. I had a woman that was a friend of the university that I worked at before I came to Oklahoma Christian, and this was her philosophy. She said, John, I don't need an estate plan. I've thought about it, and I don't have anything. Well, this woman moved from Oklahoma in the early 1940s out to California. She moved into an area and bought a little cottage during the war out there. She was the first female engineer that actually was working for a company out in California. She bought this small cottage. It's in a place that we refer to today as the Silicon Valley. She paid $8,000 for her cottage. And she thought in 1998 that her little cottage was still worth $8,000. I wish we all had bought a small cottage in 1943. Her mind changed when her next door neighbor in an identical cottage sold her little cottage for almost $1 million. And she realized, okay, well, maybe I do have something. A second reason people have said, hey, I don't really need an estate plan, it's because my family knows what I would like to have happen to my assets when I die. Well, they might. They might know what you want to have happen. But the unfortunate truth is, there are actually more problems caused in families over asset disputes following someone's passing than we want to believe. It's hurtful and it's painful, and there are families that you think get along so well, and then all of a sudden, when a matriarch or a patriarch passes away and things begin to happen with the estate, all of a sudden things come to the surface that you just didn't realize. So a second reason, hey, my family's going to take care of it, no problem, they know what I want, not a very valid statement. And finally, this next point, I own everything in joint tenancy with my kids, so I don't need to have an estate plan. Very simply, there are many ways that you can own property. One type of ownership opportunities is for you to own something in joint tenancy with the right of survivorship. My wife and I own our house. I say we own our house. We're borrowing our house from the bank right now. But Darla and I own our house in joint tenancy with right of survivorship. If I pass away, it is her house. If she passes away before me, it is my house. And so some say, hey, a real simple thing, forget having a will or a trust. I'm just going to have my children placed on all my property as a joint tenant with right of survivorship. Would that work? Well, it could work. However, there are a couple of problems, and maybe the greatest problem is when you are a joint owner with someone, all the assets that you own together are at risk in the case of lawsuits based on liability. So if I put my children as joint tenants with right of survivorship on our house, and my son or my daughter are at fault for a car accident that they cause, my house could be subject to that lawsuit. I could lose my house because of the acts of one of my children. It's not a good idea to think that this very good technique is a one-size-fits-all in those kinds of situations. And here's probably one of my favorite. I don't need an estate plan because the state of Oklahoma is going to do the right thing. Yeah, sure. Okay, right. We live in a great state. I love being in Oklahoma for lots and lots of reasons. But I really don't want the state of Oklahoma deciding what happens to all my stuff and all my relationships after I pass away. Especially when I can do some very simple things that take care of that myself. I also have seen these excuses. I don't need an estate plan because I have a will, so I will avoid probate. I don't know if you've ever heard that or thought about that. It's kind of simple. If you have a will, that guarantees that you will go through probate. You don't avoid probate by having a will. Similarly, there's another alternative, and that's having a irrevocable trust. I have a trust, so I will avoid taxes. People think having a trust automatically will help them avoid taxes. That's not true either. There are some ways that it can help, but just having a trust does not cause you to avoid taxes. How about this? I don't need to worry about this because I did a will before I went to Korea in the 1950s. Odds are there have been some important things in your life that have changed since the Korean conflict in the 1950s. Either relationships, children being born, grandchildren being born, deaths that have occurred. This is also in the world of estate planning. You don't make a decision and then it's left forever and ever. You don't have to worry about it again. Finally, I don't need an estate plan because I typed and signed my own will last week. Now you say, hey, what's up with that? I mean, there's something called a holographic will. And that's an okay thing, and you've heard about those. That's where somebody writes out what they want to have happen. Maybe they're in the hospital and they know they're passing away, and so they write out generally what they want to have happen, and there are witnesses there, and it's all okay. They write it all out, and they sign it. Well, a lot of folks want to go to the store, the business office, or go online and print out a pretty general form and fill in some blanks and then sign that and hope that that will work. That won't necessarily work. It would be safer for you to write the whole thing in your own handwriting than to take something off the shelf and fill in the blanks. Because often in probate, that will not be probated. So, lawyers sometimes are expensive. I'm married to one, so I know sometimes they're expensive. I'd like you to excise that part of that statement from this tape, please. Okay, I'm in trouble again, right? Again, yeah. Let me tell you what makes up a complete estate plan. And this is a special term of art, complete estate plan. You wouldn't have seen that had I not called it out, right? That's several items that make up an estate plan. One is an advanced health care directive. This is something that, frankly, brothers and sisters, everybody ought to have. And this is a document that the state of Oklahoma allows to be used in a pre-printed format. You can pick one up in a lot of places. You can pick them up at the hospitals. You can pick them up at your doctor's office. You can pick them up from a lawyer's office. You can go online and print this out as well. An advanced health care directive gives you the opportunity, when you are completely in control of all of your faculties, to decide what you want to have happen to you if something bad occurs. If you if you go into a persistent coma or a persistent vegetative state, and there is no hope for you to recover from that. I will tell you, and you know this, when a loved one is in a place where he or she is passing away, it's very difficult for family members to make the decisions, to pull the plug, to stop the nutrition or the hydration. It's very, very hard to make those decisions for lots of reasons. It makes a lot of sense that if that is important to you, that you not be kept alive artificially when you are dying and there's no way for you to come back from that. You should take the pressure off of your loved ones by doing an advanced health care directive. Another part of the complete estate plan is a durable power of attorney. I only mention to you that there is such a thing called a power of attorney. A power of attorney, I do a document that gives Stephen Eck the power to make decisions for me. He can make decisions with regard to some of my medical care. He can make decisions with regard to my finances. If I'm traveling or I'm doing something and I need to have some bills paid, A power of attorney would give Stephen the right to use my assets to pay those bills. And I can put restrictions on that. I can craft it in the way that I want to. But if it's just a power of attorney, when something happens to me and I no longer can actually think for myself or control my faculties, the power of attorney loses its power for Stephen. Because once I am not in a mental position to give him permission, then it ceases unless it is a specially drafted, durable power of attorney. The durable power of attorney would continue to give rights and authority and privileges to Stephen or whomever I choose to make those decisions on my behalf. That's a very important document because you need to have someone that you trust who can take care of some of those details for you when you no longer can take care of those details. Irrevocable trust, another item that makes up part of a complete estate plan. Irrevocable trust, we'll talk about it a little bit more. In some ways, it takes the place of a will, but a good lawyer will also craft a will for you in this situation where you have irrevocable trust. The will that he or she will draft for you is called a pour-over will. We're going to talk about funding the trust here in a couple of minutes, but a pour-over will takes everything that you forgot to put in the trust and it pours it over into the trust. We'll talk about some of the positives and negatives of irrevocable trust here in a minute. Last will and testament. If you have this, you really don't need a trust, but it's got some benefits to it, some positives compared to a trust, but it also has some negatives as well, and we'll talk about those. Finally, a letter of explanation. It's not required. You don't have to have this, but I have seen cases where a mom or a dad have made some decisions, and those decisions didn't really go well after they passed away, and the family really couldn't understand why the decisions were made. And so lingering doubts crept up and arose and persisted in the minds of family members. A letter of explanation why you are choosing to do certain things can go a long way in helping the survivors. Here are the positives of a simple will, very, very quickly. One, it avoids distribution under intestacy. If you don't have a will and you pass away, you really do have a will. It's the will that the state of Oklahoma has created that says this is what's going to happen to your stuff. So you can let them make the decision, or you can quite simply make the decision yourself in a will. You decide how you distribute your estate, not the state. You get to appoint the personal representative of your choosing. And by the way, you don't appoint just one person. You will appoint one and then a successor in case that person can't serve or doesn't want to serve or is unable to serve, and a third successor. So you have the opportunity to identify several folks. You can even identify a group of people to serve as your personal representative. If you have 2 or 3 children, you could appoint all of them to be your personal representative. I wouldn't advise that, though. That complicates things, especially if you have kids that live away from here, where you are. Now, wills are not just for older folks. Wills are very valuable for young parents as well. And this is the reason. You can recommend the appointment of a particular guardian or guardians for your children if something happens to you. Wills are easy to implement. They're easy to maintain. They're less expensive to have done up front than a trust is, and they can be changed. They are easy to have changed. Now, what are the downsides? One, I mentioned it before, if you have a will, your estate will go through probate. That is a given. Your will and your estate become public record. As a matter of probate, people can go and look in the court documents and find out what you had and what you're doing with it in your death. For some people, that's a concern. For others, that's really not that big of a deal. It doesn't control all property. And there are 2 items here that lots of us have, and so I just want to mention these. If you have life insurance, there is a beneficiary designation form. That is a contract between you and the insurance company. And on the beneficiary designation form, similarly with your retirement account, you have told the company where you want those assets to be distributed. I might say that I want a particular individual to get my life insurance proceeds, and I think, though, that I've changed that because my will says everything goes to my wife. Well, if the insurance beneficiary designation form is different from your will, for those insurance assets or those retirement account assets, that controls. So it passes outside of the scheme of the estate plan through the will. There are virtually no tax advantages to have a will. Let's talk about a fully funded living trust. A trust does avoid probate. If you have a trust, your privacy is protected because it does not become a part of the public record through the court system, through the probate system. So if privacy is an important thing to you, if you want your heirs to avoid probate, and by the way, probate is kind of a hassle. It takes a longer period of time. You have to step through a number of procedural hoops with the court system. With a trust, you avoid all of that. It also can be changed. You can test drive the trustee. In fact, you can be your own trustee. In most trusts, you set it up where you are your own trustee, and then once something happens to you, the successor trustee steps in. So really, if you have a trust and you put your property into the trust, it is still yours. I mean, it's not like you have created some sort of a complicated scheme that now somebody else controls your things. It is still yours. It actually might be less expensive in the long run. It's more expensive up front to draft a trust over a will, but in the long run, by avoiding probate and some of the expenses that are associated with that, legal fees, filing fees, the time factor there, it can actually be less expensive in the long run. And in some cases, it can save some taxes. But I will tell you, for most of us are concerned about estate taxes. Most of us really don't need to worry about that. If you have to worry about estate taxes, I want to be your very best friend as a university president. We can talk about that some more. Here are the downsides. It's more expensive to establish a trust. There aren't any income tax advantages. This third point, if you don't put all of your property into the trust, you might as well not have created the trust. I had been at Oklahoma Christian for 2 weeks, and a dear Christian woman out in Sayre, Oklahoma, passed away. She had 4 different assets. 3 of the assets, she had 2 CDs, she had a piece of real estate, and I don't remember what the other titled piece of property was. 3 of the 4 assets that she owned at her death were in her trust. The 4th one, she had not retitled it. It was not renamed for her trust. And so, despite her best intentions, we had to go through the probate process for that 4th item. There is limited oversight of a trust. You don't have a judge, you don't have a probate system that is looking to make sure things are happening just like you wanted them to happen. Again, that's why it's important that you have a trustee that you trust and know very, very well. Here is the first law of trusts. You must fund the trust or it is worthless. Now, what does that mean? Here it is, very simply. It's not a scary, big concept. My mom and dad are a great example of this. Good lawyer in Tahlequah helped them create trusts. They came out of their office. They said to me, "John, good news, we have trusts. It's going to be great." And I said, "Okay, have you put everything in the trust?" And they said, "What?" I said, "Well, have you put your house and have you put your cars and have you put these things into your trust?" And they said, "We have our trust right here." So what's in it, Mom and Dad? Well, nothing was in it. If you don't put your things that you have title to in your trust, it doesn't benefit you at all. It's pretty simple. changing something from from being owned by John and Darla deSteiguer as joint tenants to being conveyed to and owned by John and Darla deSteiguer's revocable living trust. Very, very simple form. Something you ought to get your lawyer to help you with when you put this trust together, if you do that. I want to talk very quickly about the disposition of estate assets with just a couple of slides, and then we have a couple of minutes for questions. First of all, I strongly believe that God intends for us to take care of our own. I mean, it's a simple teaching, I believe, in both the Old Testament and the New Testament. We have duty and responsibility to our family members, and they have duty and responsibility back to us as well. I am never, and Stephen, and none of the fundraisers at Oklahoma Christian or other places are ever taking positions that say, you need to give what you have to charity, whatever that charity is, instead of your family. It's important to take care of family. However, in a lot of cases, people also have the opportunity not only to take care of their dependents, but to do something that leaves a legacy. And this is really, really important. Whether it's a church camp, or a ministry, or a local congregation, or a Christian college, or maybe there is something that's not even in our church sphere. There might be a charity out there that you want to do something special for, and I would really encourage you to consider doing that. And this is more than just having the intention. I attended a congregation once where there, on the edge of the campus, was a big house. A couple lived there, attended this congregation, and they had always expressed their desire to give that house to the church when they passed away. It would have been a great place either for a preacher or a visiting missionary to live, or to even create kind of maybe a food pantry for the community, or even a clothing shop for the community. Well, they had told their intentions quite broadly throughout that local congregation. They passed away, and the elders were convinced that that was going to be coming to them, the church, in the next few months following probate. That couple, as much as they wanted it to happen, they never took the step of actually recording that in their will, that they wanted to bequeath this home to the local congregation. So you actually have to have more than just an intention or a desire. Now, let me talk in the realm of gifts just for a second. Lots of us have IRAs. Students, you guys probably don't have IRAs yet. If you do, I'd like to talk to you after this meeting, because I'm really proud of you. And you've probably had Kent for class, and that's why you do. We all know what an individual retirement account is. In fact, a lot of us also have a 401k or a 403b. Generally speaking, for a lot of those, you're able to put money into those before you pay taxes on them. And the idea is, at your retirement, you're able to draw money from those to assist you in the latter years of your retirement years. Well, the government, they are going to get their taxes one way or another. They either want you to pay taxes when you earn the money, or if you set up an IRA, a traditional IRA or 401k, they want to get the taxes from you when you start to draw the money out in your retirement years. Often, the tax is going to end up being 40% or more. Let me tell you, there is a way that the government allows you to avoid taxes on that, income taxes. And that is, if you take your IRA or your 401k and you make the beneficiary, the designated beneficiary of that, be a charity, a bona fide charity, a local congregation, a missionary effort, a Christian college, that money, the full amount, will pass to that charity and no tax will have to be paid on it. If you had a $100,000 IRA and you drew the money out, you might get $60,000 over the years. If you passed away, or your heirs might get $60,000 from it. If when you passed away, you're giving that money to the the local congregation, they will get the full $100,000. This is a very efficient way to make charitable gifts through your estate plan. And it's a very simple thing to do. By the way, I want to mention this. If you know a widow or a widower that you go to church with, or if you're a widow or a widower, there are a couple things that you ought to do that will really assist your beneficiaries later. One is change the ownership or title on accounts on the home that you all own together. If you own a home in joint tenancy with right of survivorship, it does pass to you if you survive your spouse. However, it's still going to be titled in both of your names. And you can very simply file an affidavit of death that then allows the property to be put solely in your name, so it will pass down to your heirs much more simply than if the deceased spouse's name is still on it. Consolidate things. It's for ease of management. Here's the idea of the affidavit of surviving joint tenant if a spouse passes away. One final slide, and then we've scheduled 5 or so minutes for questions. And this is, what I have given you is a very high-level view of stewardship in the estate planning realm. There are lots and lots of questions and lots of details. The biggest issue out there, though, is people don't think about the fact that they can be doing things or ought to be doing things. Stephen and former President Mike O'Neill, who's a very accomplished lawyer in estate planning matters, we put on estate planning seminars for local congregations. We do it free of charge. We don't come in and have everybody sign that they're giving everything to Oklahoma Christian or anywhere else. It is purely a service so people can be educated and they can decide whether or not they have assets or the means where they can take care of charities or churches or ministries that are important to them. So if you're interested in anything like that, let us know. We'd love to schedule something and try to set something like that up. Okay. Stephen, anything you'd like to add?
Just one thought that came to mind when you were talking about the IRA beneficiary designations. When a spouse passes, if the retirement account, let's say my retirement account, I list Megan, my wife, as the IRA or 401k beneficiary. If she is deceased, then at my death, that goes to her estate. When that happens, we talked about estate tax and that there's really no estate tax anymore that impacts very many of us. What we don't think about is the income tax that's chargeable to estates or to revocable trusts. So if you name your revocable trust or your estate as the beneficiary of your retirement plan, the trust or the estate will pay the income tax on that. At the individual level, we hit the top tax rate right now, the 39.6 at $450,000. In a trust or an estate, you hit the 39.6 rate at just over $12,000 of income. So if you think about that big IRA coming into the estate or the revocable trust, it doesn't take a large IRA at all to trigger that highest income tax rate at the estate or trust level. So that's another thing to do when someone passes. Just double check those beneficiary designations on IRAs or 401ks.
Very good. Did you notice the lights came on as Stephen was talking also? Yeah, that was impressive. What questions have you got?
Can you keep your IRA out of the estate by making a designation of beneficiary other than your spouse? You want to do that?
Well, yes, you can. And
between you and the IRA holder?
That's correct. Now, there are also, in many cases, if you try to identify a beneficiary who is not your spouse, you're going to have to show permission from your spouse to do that.
No, I meant after the spouse.
Oh, okay, yes.
She dies, and then you can have secondary beneficiary.
And I was not suggesting that anyone was trying to hide assets from your spouse. Please don't. But yes, you can.
You can do that.
Yes, sir. Yes, ma'am.
When you write your will,
Question is, when you do develop your will or trust, should you discuss it with your heirs? I think in the best possible scenario, the answer is yes. You want them to be informed, and you want them to know what's happening. You want them to even be able to weigh in on it. For instance, if you have several children and you want to treat them all exactly the same, and yet the reality is you have one child who is very, very gifted by God at making lots of money, and they really don't need much, or you might have a child that is particularly poor at the use of assets that they have because they make bad decisions or because they have other issues that you have to be aware of and deal with. I mean, you might actually find cases where your heirs say, "Mom, thanks for thinking about doing it this way, but we really don't need this," and you can share it with the others. Or, I will also tell you, there could be cases where, because things are so sensitive, that you decide that you can't tell your heirs what's happening. And in that particular case, and that's understandable as well, in that particular case, I think having a letter of explanation that is a part of your estate plan to explain why you've made these decisions, that could prove to be valuable.
What are you discovering about the passion that younger generations have for taking care of churches or colleges or ministries that have been a blessing in their lives compared to other generations? Is that about the same? Is that changing positively or negatively anywhere?
Well, so the question is, younger generation today, are they as passionate about taking care of ministries or schools or churches that have been an important part of their life as older generations? I think one of the things that you're seeing overall is, and this has been happening for probably the last 20 years, there is less and less loyalty among young people for institutions. And that is across society. That's not limited to the Christian realm. That's across society. Generally speaking, in the estate planning realm, the reality is most folks don't begin thinking about estate planning until they are well into their 50s. They ought to be starting thinking about it earlier, but they're not. And that also has always been the case. So I wonder, Richard, if that's actually going to translate in the future, seeing less and less loyalty to institutions. That's possible because that's how so many young people are thinking today. But then, on the other hand, and I can say this as beyond a middle age realm of my life as well, that now that I've gotten to this point in my life, I actually there is some wisdom that comes with age, I'm finding. And so some passions that I have now about taking care of organizations, as good a guy as I was in my 20s, I really didn't have those passions or desires. So my hope and prayer is that lots of us at all ages will see estate planning and other stewardship opportunities as ways to take care of these institutions that I think, frankly, are so important for the world and have been so important for us. God bless you. We're out of time. Thanks for being a part of this.